Welcome back to Lost Touch Channel. My name is Anton Vieltsin. I'm a criminal defense attorney in the Southern District of California here in San Diego. You're now watching a third video in a multi-part series dealing with conspiracy law. It probably makes sense now for you to go back and watch the first two videos. In the first one, I give you an overview and a roadmap of where we're headed. In the second video, we discuss Pinkerton liability. And now finally in this third video, we're gonna focus on the elements of the crime, meaning the elements of conspiracy, focusing on the Overt Act. So we're gonna look at one of the Supreme Court cases that deals and further defines Overt Act for us. You're now watching the third video in a multi-part series dealing with conspiracy law. So let's go ahead and jump right into it and discuss the elements of the crime. What is a conspiracy? It is an agreement between two or more persons to commit an unlawful act. Again, it's an agreement between two people plus something illegal, a crime. For example, if two of you join together and agree to throw a surprise birthday party for a friend, that's not a conspiracy. There's nothing illegal about throwing somebody a surprise party. But if two of you agree to also kill that person once he comes in, well, that's an agreement to commit an unlawful act, murder. So that's a conspiracy. But something to keep in mind, no co-conspirators need to be tried or identified, meaning that one person can be charged and the prosecution doesn't have to identify the second person. Acquittal of one of co-conspirators is not a defense. So when two people are charged, one is acquitted, meaning not guilty, the other one can still be found guilty. That's not a defense. And an agreement can be proven by both direct and circumstantial evidence. The second element of a conspiracy is that the person has to have knowledge of this agreement and voluntary participation. But something to keep in mind, the person doesn't necessarily have to know the full scope of the agreement, the full scope of the conspiracy. And often enough, people don't know the whole conspiracy. They only understand their part of it.
You know, the gill straps aren't really moving, they're being robbed. These crooks know the gill straps are out of town, so they're trying to move the gill straps permanently. They figure they look like movers, they act like movers, so who's gonna know? The Joneses. They know.
Dad, aren't the gill straps in Toledo?
I think they're being robbed. Should we call the police?
Call the police.
See, the Joneses know. If they don't tell the cops now, the gill straps will have to tell them later.
Hello, this is...
And now on to the third element and the one we're focusing on in this video, which is the Overt Act. That is the step towards the completion of the crime. It is defined for us in U.S. versus Rabinowich, which is a Supreme Court case from 1915. A very old case, over 100 years old. In Rabinowich, there was a conspiracy to violate Bankruptcy Act. What the co-conspirators were trying to do was conceal some of the property from a trustee. And the question was really the statute of limitation question. How long does the prosecution have to indict the case? If you want, you can read more details and facts about the case, but essentially that's what it was. The Overt Act, the crime of concealment, had only 1 year during which the prosecution has to bring the case, while the conspiracy had a 3-year mark. Well, guess what? The prosecution missed that 1 year mark, and the prosecution was arguing that they have more time to charge and indict these individuals with a conspiracy. So the question is, when you have this Overt Act, the crime, plus an agreement between two or more people, which statute of limitation controls? The one for the overall conspiracy or the individual crimes that each person is committing towards that overall goal in the conspiracy? Something to remember from this case, that a mere conspiracy without an overt act done towards it is not criminally punishable, meaning that an agreement without anyone acting on it and doing something towards the conspiracy is not punishable under criminal law. There must be an overt act, but again, something to note, but it doesn't have to be criminal in itself. I made examples and I gave you some in the first video in this installment on conspiracy law, where I told you that, for example, making a phone call or driving to another state, that could be an overt act, even though driving to a different state might not be illegal in itself. A person can be found guilty of a conspiracy even if he's incapable of committing the objective offense, meaning that only one person in the conspiracy has to commit an overt act. The other person might not even be able to commit it, and that's still okay. And to finish off about the statute of limitation and about this bankruptcy case, here's what the court says. A longer period for the prosecution of a conspiracy than the violation of the penal code itself is okay. Why? Well, because conspiracies are secret on their own. They're characterized by secrecy, rendering detection difficult. It takes longer for the prosecution to identify and later prosecute people for the conspiracy, because people usually take time to plot, educate each other, prepare co-conspirators. All of that takes time. And the Supreme Court says that it is the conspiracy's statute of limitation that should control, because it takes longer to be in a conspiracy versus committing the overt act. Hopefully this video now explains to you a little bit more about overt acts. You now understand all the elements of the conspiracy, and then you focused on this overt act element. I hope you enjoyed this video. Please click like, subscribe, hit that bell notification button so next time I post, you'll be first to know. And I'll see you in part 4 of this multi-part series dealing with conspiracy law.